Hi, this is your professor, Judy Paparozzi, and today on this video, I'm going to talk to you about why we brief United States Supreme Court cases in this course of criminal procedure. Most of you have never briefed a case before, and I hadn't briefed one until I went to law school in 1982, and I had to be taught how to do them, but then each night I had to brief probably 20 to 25 cases, and I'm only asking you to do 5 Supreme Court cases over this entire semester. So it's not a big deal. I learned it pretty young on how to do this, so I'd like you to learn to do this as well. I will do a separate video on how to do the case briefs. But first I want to talk to you about why you need to do them. Everything in criminal procedure that is of a constitutional proportion, like Miranda or Gideon versus Wainwright, the right to an attorney, came from a decision by the SCOTUS. Now I'm saying SCOTUS instead of Supreme Court because that's the abbreviation for the Supreme Court of the United States, SCOTUS, all capitals, SCOTUS. The Supreme Court of the United States, or SCOTUS, has the power under a very old Supreme Court case, interestingly enough, Marbury versus Madison, to interpret constitutional law or the Constitution of the United States. With that power, things like the Bill of Rights, which we know as the right to bear arms under the Second Amendment, which a lot of people are arguing about these days, the Fourth Amendment, the right to be free from unreasonable searches and seizures. All these rights are really important, but they weren't always rights possessed by all of us, even though they're in the Constitution, until the case that we're going to first look at as a class together, Mapp versus Ohio, when you guys briefed that case. You'll see that the woman, Dalrymple Mapp, whose house was searched without a search warrant, with in fact a phony piece of paper in the police officer's hands, that was because the Fourth Amendment of the Constitution, which guarantees citizens to be free from unreasonable searches and seizures, didn't apply to people who were arrested in a state, unless they were arrested by the federal government via the FBI. So that was a federal right that had yet to be applied as a state right. So the evidence that was seized in that particular case, which was pornographic material, was actually used against Dalrymple to convict her of possession of pornographic material, even though the police had no right to be in her house under the Fourth Amendment. But until the SCOTUS decided that the protections of the Bill of Rights applied to state as well as federal defendants in criminal courts, those arrested in state courts didn't have access to all these wonderful rights that we think we have as just being citizens of the United States. So until 1964, whenever the case of Mapp was decided, that right didn't apply to you and me if we were arrested by a local police department, say in Lumberton or in Pembroke or in Wilmington, where I'm from. Those rights didn't apply to us because they were rights for federal inmates or criminal defendants, because it was the federal Constitution that was being used. So it didn't apply to a state arrested person. Most of us are arrested within the states. Federal crimes are like bank robberies, kidnappings across state lines. And those are pretty rare compared to the amount of state crimes, which are like robbery of a convenience store or rape, murder, etc. They're all prosecuted by the state and not by the federal government. Okay, remember we have 2 types of law enforcement in this country. We have the main type, which is the state, anything within the state, like the local police, the sheriff, the state police, or the feds, which are the FBI, etc. Not everybody's arrested by the FBI, so those rights that are in the federal U.S. Constitution as opposed to our state Constitution weren't applying to us until Mapp versus Ohio. So this brings a really critical point to all criminal procedure students, that while we may possess the rights to certain things, until the Supreme Court interprets them as these rights as applying to particular instances, the right may not be available to us. Luckily, at this point in the history of our country, 225 years later, etc., a little more than that, all the protections under the Bill of Rights, the different Bill of Rights, apply to us even though they're federal rights, they apply to us whether we're in a state court or a federal court. So that's the good news. But all this had to develop over the years as the Supreme Court made decisions. So I have you brief 5 of the most important criminal cases: Mapp versus Ohio, Terry versus Ohio, Miranda versus Arizona, Gideon versus Wainwright, and 2 death penalty cases, so you can see how the Supreme Court decided that certain rights applied to all of us via the Constitution, but no court had interpreted in that way. And of course, the Supreme Court is the ruling authority on cases of constitutional dimension, like the right to an attorney, which is Gideon versus Wainwright. So that's why we brief the cases. And in the next video, I will explain to you how we brief the cases. So welcome to Criminal Procedure.